Hear ye, hear ye, hear ye. All persons have anything to do for the honorable justices of the appeals court now sitting within the Boston in the Commonwealth. Draw near, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. Court is now open. Please be seated.
Good morning, everyone, and welcome to the Appeals Court. This is the first day of the start of the new term. I am Chief Justice Amy Blake. I am pleased today to be joined to my right by Justice Kenneth Desmond Jr. and to my left by Justice Sabita Singh. We are the panel for the 6 cases that are scheduled in this courtroom today. I know most of you have been here before, but just a few brief reminders. Each side is permitted 15 minutes of argument. There is no rebuttal. I can assure you that we have read all of your materials. Use your time wisely. I suggest you get right to your arguments. I know that we have a paired case later on in the morning, and before that case is called, I will explain how we're going to handle the time on that paired case. We are likely going to take a brief morning recess after the 3rd case. With that, I will call the first case of the day, COMMONWEALTH versus Dwight M. Landry, docket number 23P1082. Counsel, good morning.
Good morning, Your Honors. The prior version of Section 131 was specifically condemned in Bruin for the reason that it set forth an...
Can you tell me your name?
Owen Murphy for Mr. Landry. Excuse me. Thank you, Your Honor. So like I said, Section 131 was specifically condemned in Bruin for the reason that it set forth a good cause requirement, and therefore, plainly based on that reason, I think it's quite plain, obviously, that the version of the statute that Mr. Landry was charged under was unconstitutional, and therefore his conviction should be vacated.
Why would we reach the constitutional question when the Commonwealth has conceded that your client is entitled to a new trial for the lack of instruction on non-licensure, putting aside the sufficiency piece for a moment? Why would we reach the constitutional claims?
It's a different remedy under the sufficiency issue versus the constitutional issue. So first, for the sufficiency issue, the remedy is a new trial. I think for the constitutional issue, his conviction has to be vacated outright. And in any event, the issue is going to be fundamental to any retrial, so I think guidance from the court on it would be appropriate. But again, it really comes down to the remedy, and I think, therefore, it's necessary to reach that issue. In addition to the Section 131 issue, prior precedent and judicial decisions or legislative action both mandate that this court interpret Section 10A under the presumption of scienter, and I might be pronouncing that word incorrectly, so bear with me. But without doing that, there's a grave risk that Section 10A punishes constitutional conduct and not wrongful conduct, because somebody's status is the crucial element which separates wrongful conduct from innocent conduct. And without the presumption of scienter, there's simply nothing to stop the government from simply prosecuting somebody for exercising their Second Amendment right.
Can I ask you a question on the sufficiency claim?
Please.
You claim that the gun is an antique, and are you required to plead an affirmative defense relative to that, and if so, did you?
I characterize the gun as an antique for the purpose of demonstrating that it's not a conventional firearm, but not to raise the affirmative defense.
So you're not arguing the 1900 manufacturer jurisprudence?
No, Your Honor.
You're arguing operability?
I'm arguing sufficiency, that it was a conventional firearm. And
what do you mean by conventional firearm? What are you saying about it was not conventional? The ballistician testified that he was able to shoot.
Correct. Yeah, I think so. The operability goes to the defendant has to have knowledge that it's actually an operable firearm if it's not a conventional firearm, and
what's unconventional about it? That's the piece I don't understand.
Yeah.
I mean, I know he had it around his neck, but it's 4 inches. We have the photographs. It was in the holster.
I understand, Your Honor. Our position is that it's a small decorative ornamental piece and
loaded.
That was loaded,
I
but
know he was found not guilty of loaded, but for purposes of sufficiency, we look at everything.
right. That's true to an extent. I think that when you're determining whether there was an error or not, you can assess the record based on the facts found by the jury. And
Give me the facts that you say make it the gun, I'm going to use your word because it doesn't appear in the statute, unconventional. What does that mean?
again, that it's a small decorative ornate piece that was being worn as a piece of jewelry, and that it had jewelry-like features like the pearlescent handle and the small nature of it. And that would be Mr. Landry's position on that.
Why do you think he pointed out to the police officer that he had it?
I'm sorry, Your Honor?
Why do you think he pointed out to the police officer that he had it?
I think anything on that would be speculation, but I think the record supports the view that he pointed it out to the officer to avoid any mistaken belief on the officer's part that it was a firearm.
Well, it was
Not
a
that he
firearm.
himself believed that it
It was
was.
a firearm, right?
What's that?
It was a firearm.
It was. Yeah.
How's that a mistaken belief?
From Mr. Landry's perspective, he was alerting the officer that he had what could be mistaken for a firearm, what was actually a piece of jewelry handed down from his grandfather around his neck. So he was.
Was it that or was it the opposite? He pointed out that what could be mistaken for a piece of jewelry is really a firearm.
Yeah, I think that's a question for the finder of fact.
On your constitutional challenges, I see them at least three. There's a due process, a disproportionate punishment, and a Second Amendment violation. Can you tell me which of those were preserved below?
I'm not sure that any of them were preserved below.
So what's our standard of review?
Well, I think it's de novo. There's just simply questions of law.
Think it's de novo or it is de novo?
I'm sorry, Your Honor, I'm not.
Think it's de novo or it is de novo?
Certainly the questions of law are for de novo review. The prejudice standard, I guess, would be substantial risk. But when reviewing the actual legal questions, they're pure legal questions that mandate de novo review. So I'm sure about that. To the extent that they weren't preserved, I guess the prejudice standard would be substantial risk.
On the disproportionate sentence claim, hasn't the SJC spoken in Jackson on that?
I would say no, because I don't think there really is any reasonable debate that the fundamental landscape of our view of the Second Amendment has changed since Jackson, particularly obviously after Bruin and Guardado, which changed the nature of the offense from possessing a firearm to failing to comply with a licensure requirement. And Jackson would.
Bruin or Guardado changed 10A in the sense that Jackson held at 909 that the sentencing scheme was not cruel and unusual in a constitutional sense. How did Bruin alter that?
Bruin altered that because it clarified that possessing a firearm in and of itself is not impermissible conduct. And Jackson reviewed Section 10A under the premise that possessing was the gravamen of the offense. Now it's turned into a licensure offense, and when we view it from that perspective, it's grossly disproportionate to the offender, to the conduct, and to every other licensing law within the Commonwealth. For instance, operating without a license poses the same risk of danger, ostensibly, as carrying a firearm without a license, but the penalty under that is up to 10 days, not a mandatory 18-month sentence. And so there's no status offense within the entire Commonwealth, or from what I can tell, anywhere in the country that would require an 18-month mandatory sentence. It's grossly disproportionate to somebody who may be an innocent offender, somebody who simply didn't mean to disobey the law by not obtaining a license, but simply was unaware that they had to or neglected to for some reason or another. It's somebody who could be really an innocent person.
Are you bringing this as a facial or an as-applied challenge or both?
both. And on that point, if I could go to the Second Amendment issue, I know in my brief at one point I stated that it could be applied within constitutional boundaries in some instances, Section 10A that is, but I now realize that that was incorrect based on Donald, which talks about Section 131 and the proper cause elements, and so I'd retract that analysis.
I appreciate that.
It's important to note that under Section 131, every applicant was required to show good cause. And even if they did so and they weren't disqualified under the statute, the licensing authority only didn't have to issue. It was permissible that they issue. It was also permissible that they didn't issue. So,
Does Mr. Landry have standing to bring an as-applied challenge where he never applied for an FID card?
I think that he does, and the reason is that if you look at Marquis, it talks about there's an exception to being able to obtain standing if you fail to apply for the license, and that's what if application would have been futile. And in the Commonwealth's brief, I could tell you that Mr. Landry didn't have any knowledge of this arrest warrant, but had he actually applied, it would have been futile because there was apparently an outstanding arrest warrant, which he was unaware of until he actually was stopped.
What was that warrant for?
What's that?
What was that warrant for?
I'm not sure. I don't know what, it was an arrest warrant. I don't know the associated charge.
You think that matters?
I think what would matter is that if he was not, well, under the statute, I don't think he could actually, he would have been statutorily barred from applying because of the outstanding arrest warrant. I don't know that it matters what the accusation was. The accusation may have mattered if he wasn't statutorily barred and then they got to the discretionary standard. If it was a crime of violence or demonstrated his inability to safely own and operate a firearm, then the substance of it, I think, would matter. But in terms of this argument, I don't think it does, because to get back to the standing point, it would have been futile for him to apply.
Can I go back to the sufficiency question for a moment?
Yeah.
After he told the officer that he had this around his neck, it was determined that it was a .22. It had 4 live bullets and 1 discharged casing. So, and because it's a revolver, the ammunition was visible, obviously, from the gun itself. So, on your question that you raised of knowingly, 4 live bullets and 1 discharge casing, light most favorable to the Commonwealth. Help me with that.
We're talking about
Sufficiency.
Yeah, light most favorable to the Commonwealth is that there was no evidence that he knew that it was operable. Yes, there's ammunition in it, but there's no evidence that he's the one who fired it, that he ever inspected it, that there was nothing at all speaking to his knowledge of it. And again, I think we have to take that fact as determined by the jury. And the jury found that he was unaware of the ammunition within the firearm.
If the jury concluded, which it appears they did based on the conviction for possession, that the firearm was not an antique or, quote, decorative ornament used as jewelry, tell me, I guess I'm still struggling with this unconventional firearm. Obviously, the jury rejected the antique component of your argument at trial. In the light most favorable, didn't the government prove that the defendant knew that what he had around his neck was a firearm within the generally accepted meaning of that term?
Yeah, I understand the question.
Because obviously, if the evidence is insufficient, you're not getting a new trial, right? You're getting a not guilty. So this is an important piece. Commonwealth has conceded a new trial on the licensure piece, but I'm really trying to understand your sufficiency claim.
Right. I don't know that I have a better way to explain it other than the the makeup of the gun itself puts it outside the category of just a conventional firearm that we think of a conventional firearm as being. And so based on the definition of conventional firearm, I would say that this does not meet the definition based on its ornate nature.
What is the definition of a conventional firearm?
I think a conventional firearm is something that
Not what you think it is. What's the definition of you said it doesn't meet the definition of a conventional firearm. I'm asking what that is.
Yeah, I don't know that there is a definition from this court, but I could give you my opinion on it.
He says that it's an antique revolver, right?
Right.
So what would make it antique? If it was manufactured before 1900?
Right,
But we know that this manufacturer wasn't around until 1920 or 1930 or something, right?
I think if you take judicial notice of the Commonwealth's factual contention within its brief, then that might be a true statement.
You haven't suggested in your brief that the manufacturer manufactured the weapon before 1900, have you?
I'm not suggesting that it met the definition of an antique, correct? I called it antique just
So if we take out antique, then all we have is he tells the police officer it's a revolver. Would you say a Derringer is an unconventional firearm? You know what a Derringer is?
vaguely. No, I actually probably don't know what it is.
Small gun. Sometimes you see them in westerns. They look like they may hold 2 shots.
Strapped to somebody's ankle, yeah.
The police officer described this as a Derringer at trial. Derringer-type firearm.
I guess that, again, depends on what the term of conventional means. It's not conventional in the sense
Maybe
that...
this will help you. This is what the judge instructed the jury. This is at transcript 2, page 6. If the firearm, quote, was a conventional firearm with its obvious dangers, the Commonwealth is not required to prove the defendant knew that the item met the legal definition of a firearm.
Yeah,
So the obvious dangers, we have 4 live bullets and a spent bullet in the chamber.
but the defendant, right, I'm trying to parse this out of my head right now. I don't think that the firearm itself, putting aside the ammunition based on the fact that the jury found that he didn't know about it, I don't think the firearm itself would be so obviously dangerous to somebody based on the ornate and decorative nature of it is our position. It's not just obviously a dangerous firearm that anyone would believe that it was. And so that's our position.
Let me pause you. Your time has expired, but I want to check with the panel. I see no further questions, so we will have to leave it there. Thank you very much, counsel.
Thank you.
Attorney Punch for the Commonwealth.
Good morning, and may it please the court. Assistant District Attorney Dylan Punch on behalf of Middlesex County for the Commonwealth. The Commonwealth agrees that the defendant is entitled to a new trial consistent with Guardado 1 and Guardado 2 as to his conviction of carrying a firearm without a license.
So you say that we shouldn't reach the constitutional questions because he's getting a new trial. But Mr. Murphy makes the argument, and it's a compelling one, that if this is a constitutional question, he's entitled to a not guilty. So why shouldn't we reach the constitutional questions?
Well, Your Honor, as a preliminary matter, and as this court's aware, as a general principle, it doesn't reach unnecessary constitutional issues when there are grounds to resolve that are non-constitutional.
There's a big difference between a not guilty and a new trial.
Correct, Your Honor. And there would be a big difference. However, the Commonwealth's position is that the statute is not unconstitutional, and the relevant provisions of Section 10A and its companion licensing scheme, which at the time of the defendant's conviction was Chapter 140, Section 131D. It essentially has 3 separate provisions. You have the good reason provision, which was struck down in the wake of Bruin. But it also has the prohibited person and unsuitable person prohibition, provisions, which are still good law. And the defendant, as it's been pointed out, himself was a prohibited person. And in his principal brief, I know he's since retracted it, but he agreed that there are applications where Section 10A would be constitutional, citing those, I believe it was people with certain mental illnesses or violent histories and otherwise unsuitable or prohibited persons. And to prevail on this facial challenge, he would have to show it's unconstitutional in all its applications. And even the revised law still prevents prohibited persons and unsuitable persons, such as the defendant was at the time of his arrest, from obtaining a license to carry firearms, Your Honor. So the facial challenge fails.
What about as applied?
He never applied for one, Your Honor. I believe that was in Commonwealth versus Marquis.
He
But
doesn't have standing.
he has no standing because he never applied for one. And it's not that he was statutorily prohibited from applying for one. He was statutorily prohibited from receiving one as a subject of an act.
We know in the record, your brief says that it was a default warrant when he was stopped for speeding. Is there anything in the record that tells us what the underlying charge was for that warrant?
The warrant itself is in the record. I don't know what it was for off the top of my head, Your Honor. Now, as to the defendant's sufficiency challenge, the Commonwealth presented ample evidence. He told the police that he had a revolver. It was in a holster around his neck. As this court has pointed out, it had 4 live rounds in it, a discharge casing indicating that it had been fired. And the Massachusetts State Police test fired it and confirmed it was capable of discharging a shot, and it was fully operable.
You know of a case, a reported case in Massachusetts that defines, quote, a conventional firearm?
Yes, Your Honor. I believe the best case would be Commonwealth versus Watkins. That's 98 Mass App Court 419. It's from 2020. And they were discussing the definition of a firearm. It was Chapter 140, Section 121. And as relevant to this case, a revolver with a barrel shorter than 16 inches that's capable of discharging a shot would be a firearm.
And they use the word conventional?
I'm
I
not,
just don't know where that word came from other than counsel's brief. I'm trying to understand if that has any legal significance.
gotcha. I don't believe that they use the word conventional, Your Honor.
Watkins defines a firearm.
Correct, Your Honor. And I believe it's a question of fact for the jury. That's from Commonwealth versus Sampson, 383 Mass at 761, whether or not it is a firearm. And they were properly instructed that if they find it was a firearm with its obvious dangers and characteristics, that they could infer the defendant knew it was a firearm.
Not adopting conventional as part of some jurisprudence about what a firearm is, that word.
Certainly not, Your Honor.
Okay.
Now, because this court, as discussed, doesn't generally reach these unnecessary constitutional principles, the Commonwealth would suggest this concludes the court's inquiry. The defendant can raise his constitutional issues at a new trial where they can be properly addressed.
Do we review, if we reach the constitutional question, are we reviewing them de novo?
Yes, Your Honor. I can, if the court has no more questions, the Commonwealth can rest on its brief, or?
Let me check with the panel. Seeing none, we'll take the rest of your argument on your brief. Gentlemen, thank you very much. The case was well argued. It is now under advisement. For all the newer lawyers in the courtroom, you just saw opposing counsel shake hands. We do not see that enough here in the courtroom, and I appreciate that from both counsel. Commonwealth versus Warner J. Donaldson, docket number 24P997. Attorney Rose, good morning. You okay? Okay.
Good morning, and may it please the court. My name is Rachel T. Rose, representing Warner Donaldson. Mr. Donaldson's trial was so unfair that it should leave you with serious doubt that he committed this robbery. The manager's identification was deeply suspect, and the rest of the evidence didn't connect him to the crime at all. Donaldson's DNA was found in his own home, just like everyone else's would be, but it wasn't found at the crime scene. That crime scene was a busy convenience store that didn't have anything in it to distinguish the robber's scent from everyone else's, so it had nothing for a sniffer dog to track.
What do you say to kind of the totality of the circumstances? Maybe any one thing standing alone may not have a lot of heft, but the totality of the circumstances, the fact that the manager knew Donaldson, knew his voice, knew where he lived, I think had purchased something.
He bought a fridge from him the week before, which was never brought up at trial, interestingly.
Hold on. Purchased a refrigerator from him. Able to point out, like I said, his house. Had a conversation with him days before the robbery about how to jimmy the door or leave the door such that it would be able to be opened versus the automatic locking system. Coupled with the mask that was recovered in his house with his DNA, suggesting that it wasn't somebody else wearing that mask. So when you put all of that together, notwithstanding that the police got the manager and the clerk kind of confused a little bit, have my own theories as to how that happened. But you don't think all of those things together, notwithstanding that the canine led from his house. I understand he got distracted by the rabbit, but still followed a trail to the house.
Well, there's no trail to follow because the clerk kept serving customers.
He ironically went from the store to his house.
But he couldn't be following anything. The clerk kept serving customers.
Whatever he did, the dog went from the store to the defendant's house.
Well, the police already knew where the defendant lived. So there's no question here that the manager knew who he was accusing. He knew who this guy was. He was certain that this guy was the robber. It would have it's very difficult to say, however, that wouldn't have made a big difference for the jury to know that he knew this guy. He was willing to say just about anything to police so that they would arrest his regular that annoyed him so much.
Why do you say that?
Because he kept giving different versions to them at the scene. These are detailed versions. He says first that he's in the back room. He hears the voices getting louder. He comes up to the front just in time to see him running away. This is not something that police would just make up on their own. He told them something that was detailed and wrong, and he gave them another version when they brought him to the police station that was both detailed and wrong.
And did all of that come in before the grand jury and the petite jury?
The grand jury would have had to dig for it. They had the videos.
Come in before the grand jury.
It was in the videos. It was not presented to them. It was in the videos proved that he was wrong. They would have had to have watched them and know what they were looking for.
Was the video presented to the grand jury?
The video is a part of the evidence before the grand jury. Going back here. Anyway, the manager's original statements were presented to the grand jury as if they were true and then concealed from the petite jury entirely, so neither of them had the context they needed to judge the credibility of that crucial identification of Donaldson. At trial, he claimed to have made it through the robber's heavy disguise from a few seconds of silent video, even when the clerk who saw him close up and was the one robbed and also knew Donaldson as their regular customer did not.
Can you slow down a little bit, please?
That identification was necessary to get a conviction because the clothes in the house, Donaldson's house, were not an exact match to the video of the robber in the clerk's description. The pants had the wrong stitching and they were the wrong size, extra large, but the clerk said the robber was skinny. You can look at the pictures of the Donaldson sneakers yourselves. They don't have a reflective toe. The thick work gloves police found weren't the same gloves the robber was wearing because the clerk said those were latex. There are some latex gloves on top of the BB gun in the search warrant photos, but those aren't Donaldson's. They belong to police. And if the robber was wearing gloves, how's Donaldson's DNA on his BB gun supposed to prove he's guilty anyway? There wouldn't be DNA on that. For the ski mask, the most you can say is that the pattern could be similar if you assume a lot of brightness distortion. The eye area on Donaldson's mask is fairly open, though, and the pictures and video of the robber's mask seem to have that area covered. It's certainly not an exact match. He didn't get an acquittal because the prosecution hid the ball at every stage of this case. The magistrate got a false picture of the evidence, the grand jury got it too, and then the jury most of all. Even if it's possible to claim less than overwhelming prejudice from one of these errors in isolation, it can't be done when they're considered together. And it shouldn't, because leaving this conviction in place is an endorsement of misconduct. Excusable negligence is police not following up or not knowing they're getting bad information, not turning a blind eye to obvious fatal discrepancies. There's two different conflicting versions of how the manager identified Donaldson in the same police report, and neither one can possibly be squared with the silent video they all watched right alongside him. If putting statements police should have known were false in front of the magistrate to justify a search still doesn't merit suppression, that's going to be a strong incentive to do it again anytime you'd like to search without probable cause.
Why do you think the police put two different, what did you just say, two different what?
It doesn't seem like it's deliberate, if only because if it was deliberate, they would have done a better job of lying about it. It seems like...
So if it's not deliberate, what is it?
Reckless. It's reckless disregard for the truth.
Could it just be a mistake?
It's not
Human.
It's not just one mistake, though. It has to be multiple mistakes. He has to write his own police report without realizing it doesn't make any sense. They have to watch the video without realizing that it's proving that what the guy is saying to them is completely untrue. They have to look at the search warrant affidavit and say, oh, well, it only includes one version that we know is false, but that's going to be good enough. It's just at every stage.
And was all of that argued before the petite jury?
No, none of it was.
None of it was.
None of it was. They never heard that he had originally lied to police. This is part of the problem.
Did the video come in?
They had the security videos of the robber were there.
Did the video come in?
What video?
The video of the manager down in the empty office, or not in the office.
Oh, the video of the manager telling police when they got there that he was the one robbed? No, that didn't come in. That was an exhibit for the search warrant, for the suppression motion, but it was not at trial. So presenting the same statements that the prosecutor certainly knew by then were false to the grand jury without a word of warning. This is a bad incentive that encourages a misleading presentation to say it's no big deal because they could have disproven it themselves if they'd tried. The grand jurors aren't expecting to do that because they think the prosecutor is going to be giving them a straightforward look at the evidence. That they would have had to look for themselves to discover that the central identification the prosecutor was offering them was based on a lie so seriously tainted the presentation that the indictment should not be allowed to stand. Similarly, the manager's multiple self-contradictory reasons for why he was so sure that Donaldson was a robber bring his identification into doubt, and it makes withholding them from the jury improper. They should have heard him say, confidently, repeatedly to police that he'd heard the robber's voice himself and saw him close up, so that they knew that confidence wasn't to be trusted. Lumping on scientific evidence that sounds impressive but doesn't actually tie the defendant to the crime isn't a prosecutorial tactic that should be rewarded either. Whether his DNA is in his house or the police dog was chasing a rabbit, either way, none of it says anything about whether he robbed the store. Presenting it as if it does wastes court time and expense to add only to the appearance of evidence against the defendant. It's overwhelmingly prejudicial. Similarly, it's not arguing from the evidence to tell the jury it was somehow suspicious for Donaldson's defense to point out that 2 other people's DNA was also on the ski mask that they were claiming was the same mask seen on the video. Responding to the evidence offered against you doesn't equal an admission of guilt. And when you say his trial testimony is a confession, you should have more of a basis for it than the defendant shouldn't have known how much he was accused of stealing at his own trial. They did say it was around $800. The jury just hadn't heard it before. It's asking them to draw what you know is an unsupported inference, to claim that the defendant confessed because he knew what the evidence was against him. It's fundamentally unfair. The Commonwealth repeatedly used underhanded tactics to push forward what amounts to a paper-thin case against Donaldson. They don't deserve another shot. I'm asking you to reverse the convictions and dismiss the indictments, either because they are obtained via a misleading grand jury presentation, or because Donaldson is entitled to suppression, and without the fruits of the illegal search, the evidence against him cannot meet the burden of proof.
Can you address the denial of the motion to continue?
Well, I'm not sure what you want me to say about it. I think at that point it was clear it was the wrong...
Am I right that there was no post-trial motion for a new trial based on ineffective assistance?
No, this is...
Brought for the first time here.
This is the first time.
And so what is apparent in the record that would cause us to believe that trial counsel was ineffective? Right, 'cause this was basically on the first day of trial that counsel sought to withdraw.
During jury selection and then repeatedly throughout the trial. I mean, it's what counsel failed to do, which is why there's not, all of her actions are explained here. She should have objected to the dog and the DNA evidence. She should have tried to get in that the manager lied to police. And it's obvious that she's not doing these things because she's so shaken up because the defendant's yelling at her and she wants to leave. It's just, I understand when a defendant has gone through multiple attorneys and is, waiving his right to this, because this is his first request for a change in counsel. He's having some sort of serious problem. Admittedly, this is my weakest issue, but I think it really helps bring all of the others into context as to how unfair this trial was.
Could you remind me what the manager lied to the police about?
What's that? Sorry?
The manager, you say, lied to the police?
He did. He lied to the police repeatedly that he was there. He saw the robber in person, and that's how he knew it was his regular.
Well, he was on the premises. Was he not on the premises?
He was in the basement, stairs away. He said he couldn't hear anything. The clerk had to call him on the phone for him to come up, and the clerk didn't do that for a while. He kept serving customers. Then he called the manager. Then the manager came up, saw the video, kept serving customers, called the police 15 minutes later.
Did the police say, and I'm not sure, that at one point when they were speaking with the clerk, I might get this reversed, they thought they were speaking with the manager, or when they were speaking with the manager, they thought that they were speaking with the clerk?
I don't recall them specifically saying that during the suppression hearing, but I wouldn't be surprised.
Why do you think that this manager would be lying about this particular defendant?
He hates Donaldson.
Why did you hate him if you purchased a fridge from him the week before?
Maybe it was a bad fridge. But he's very certain instantly without having any real basis for being so certain, and he's willing to lie about it. He's convinced that if I was robbed, it must have been this guy. And that's all very well, except you have to actually give that to the grand jury, to the magistrate for the search warrant, and have them go on what actually is and not what he is claiming when you know it's not true.
You concede that this was a difficult defendant?
Certainly during trial, yes. He's been a wonderful client for me. We can't trust the verdict this trial produced because the jury didn't get the full picture. If they hadn't been told he'd confessed, if they hadn't been told he'd been implicated by the DNA in the dog, if they had known the manager didn't seem to care what he told the police as long as they arrested his regular, this court should be left with very serious doubt over whether that trial would have the same outcome. If there are no further questions, I'll rest on my brief.
I see none. Counsel, thank you very much. Attorney Locke. Good morning.
Good morning. May it please the court. ADA Michael Locke for the Commonwealth. Starting with the suppression issue, the motion judge here held an evidentiary hearing. She initially determined that she didn't actually need to. The defendant hadn't met his burden for an evidentiary hearing, but she held one anyways. She took live testimony, she watched the videos, and she determined that at worst, that it was negligence by the police here, and there was no evidence that there was intentional or reckless disregard for the truth here in the search warrant.
If at worst it was negligent, is there any remedy for the defendant in that regard?
No, negligence is not enough for a search warrant to suppress the fruits of a search warrant. Here, I think it's pretty clear that there was obviously some confusion about whether it was the clerk or the manager who had been robbed. I think based on my review, it seems like the manager was trying to be more helpful to the police and that he had adopted some statements that he had talked with the clerk. And I think that is probably what happened, is the manager was saying things that he heard from the clerk and then didn't correct the officers when they assumed that he had been the one that was robbed. That's just my reading of it. I was trying to piece it together too. I think that's what happened here. And that's simply just not enough for a remedy for suppression here.
Do you know if the clerk and the manager look alike?
I do not know, Your Honor. We have the interview video of the manager was admitted and viewed by the motion judge at the motion hearing, but I don't believe I don't know if there were there were still photos from the surveillance camera during the robbery where the clerk was at the front desk, but I don't think that those were admitted at the motion hearing. So I don't know if the motion judge saw the two of them together or not.
At page 26 of your brief, you argue that without the statements, there's still probable cause. So can you address that?
Yes, Your Honor. So even if you take out those statements that the manager had actually seen the robbery happen, you still have the manager identifying who it was to the police. He then drives to the defendant's home and comes back and tells police, oh yeah, this is the guy, and this is where he lives. He then goes and does an interview with the police, and he then identifies the defendant in a photo array. And obviously there was a robbery. They had seen the surveillance video. Someone had robbed the store. So even if you had taken out those statements, I believe there was still probable cause.
And they also found a BB gun of some sort when they did the search warrant?
Yes, yeah.
And shoes that appear similar in kind to the ones that are depicted on the video?
Correct, Your Honor. And a very distinctive looking mask, which is, I would submit, clearly the same mask. When you look at the still images from the robbery and you look at the mask that was recovered, it's a very distinctive black with a white skull markings on it. I would submit that it's pretty clear that that's the same mask. Moving on to the motion to dismiss, the Commonwealth presented all the evidence about the manager's statements to the grand jury. I'm not sure exactly what the defendant wishes the Commonwealth would have done. The Commonwealth has an obligation to had an obligation to present those statements because they were conflicting. They were exculpatory to the defendant, and they were before the grand jury. The grand jury had the video. They had both sets of statements. The prosecutor at the grand jury specifically asked one of the officers where the manager was during the robbery, and he said he wasn't. He was in a back room. He was in a different room. He wasn't there. And as the motion judge found, it's up to the jury to resolve those factual discrepancies. So there was no error in the denial of that motion. Then the DNA and the
issue we're reviewing for substantial risk?
I'm sorry, Your Honor?
The dog DNA issues we're reviewing for substantial risk?
Yes, Your Honor. There was no
argument for substantial risk?
Yes, Your Honor.
And the motion to continue is raised for the first time on appeal?
Correct, Your Honor. in its abusive discretion on the denial of the motion to withdraw. If the court has no further questions about any of the issues, I'm happy to rest on my brief or happy to answer any additional questions.
I see none. Thank you very much. We will take your argument on your brief. Counsel, thank you very much. The case is under advisement.
Thank you.
Our next case is Commonwealth versus Todd Corbett, docket number 24P223. I remind counsel that the case is partially impounded, so no names of the victims. Attorney Benyon, when you're ready.
To the Chief Justice, and may it please the court. The trial court's categorical ban on cross-examining the Commonwealth's sole witness about his then pending serious out-of-state charges and custody status deprived the defense of a constitutionally meaningful opportunity to present its core theory of bias and motive, and that was not harmless. So the problem here is that the defendant has a right to show bias. Now, the judge seems to have adopted the Commonwealth's idea that of timing, but I want to just walk you through the timeline quickly. But
before we reach that, so we'll say that the judge did allow cross-exam on the mass pending cases, right?
I'm sorry, on the what?
On the Massachusetts
Oh, yes.
open matters that he had?
Yes.
Okay. And it's true that he made the allegations against Mr. Corbett before he was arrested or committed any acts in Nebraska. Is that fair to say?
Yes, that's also true.
And is there a case that you can cite where a lawyer has been found ineffective for failure to cross-examine on open matters, out-of-state matters? Any case?
Not that I'm aware of.
What's your close? So how can we say that's ineffective if there's no case out there?
So ineffective is kind of the way I tie it up, just because of the way it was. It wasn't set up the way I would have done it, by putting in the materials like in an ID. I think actually what trial counsel did preserved this issue well. First the attorney, let me just get my brief here. The judge had an opportunity to go over the issue of the out-of-state evidence. It's in the pleadings. It's in the transcript.
And the judge thoroughly did that. Would you agree?
Yes.
Okay.
And in fact, the idea that it seems that they had all these materials that I submitted from Nebraska with them. Just if you read the transcript, you can see that they're referring to some pretty specific language. But again, that is public record. I ask you to take a look at it. If not, then that's where I showed, or I believe the trial counsel was ineffective for not putting in those materials for this court to review. That's, I think, the only way I was looking at trial counsel ineffectively. It's kind of as a way to sum up the end of the brief. But walking you through the timeline quickly, yes, he had the Massachusetts charges by the time of the Singh interview. The initial, whether you want to call it a lie or the truth, that's for the jury to determine. Where the allegations come up against Mr. Corbett come in that Singh interview, where the Massachusetts charges are already there. Okay, so the Mass charges predate the Singh interview. It could be a way to curry favor there, but then and I wrote this in my brief, but then as he's released back to Nebraska, as he commits the Nebraska crimes, his motive to lie doesn't go away. In fact, it becomes stronger after the Nebraska incident.
How so?
I'm sorry?
How does it become stronger?
Because he then has a greater incentive to curry favor with the Massachusetts government because they're now prosecuting Mr. Corbett. I show that actually that's what occurred. The ADA sent a letter to the Nebraska ADA's office, which was read. I put it it's in the transcript that's in here. So there is an incentive for him to keep telling the lie if it is a lie. And that's one of the reasons why we need to take a real strong look at this case. I think this is an interesting issue. It's an important issue because it raises real constitutional concern. You know, none of us were there at those moments when Mr. Corbett and this young man were interacting with each other. And so all we have is this young man's testimony, and that is it. So it's his believability or not. If you look at the hotel receipts, they don't tell you anything except for the fact that the young men were staying in the hotel, which they admitted to because they didn't have ID. They were scamming people, so they needed Mr. Corbett to come in and just sign for it, which...
So just so I understand, so at bottom, is it your theory that he fabricated this sexual offense scenario, I think he was 15 at the time, in order to curry favor with the government? Is that the theory?
The theory is essentially, yes, that at the Singh interview, where he's in trouble.
We agree that there's no way he could consent to the sex?
Yeah.
Okay, so go ahead.
So at the Singh interview, yeah, he has an incentive. He has the Massachusetts cases already, but there is also the stabbing that has occurred. He's part of that, so he has definitely an incentive to fabricate, and this is a person who does fabricate.
This is a 15-year-old runaway.
This is a 15-year-old runaway, that's right, who's heavily addicted to drugs and other things that, and so...
Was he heavily into drugs before he got introduced to the meth with the two other runaways that he ended up partnering?
The record is silent on that. It could be inferred that he started that first night in Boston, starting with meth, or it could just be a gradual progression. All he says is, I had never tried meth before. So from that, you could also infer that he had tried, for example, alcohol or maybe marijuana or something like that. But the record is silent.
What do we make of the one not guilty, though, right? You say that it was error to exclude this evidence, but we have a not guilty.
So I think actually that helps my client more because that was with respect to the...
dissemination.
That's right, with respect to his testimony about videos that he had seen at Mr. Corbett. So that tells you that the jury is listening and they're relying on what this person is saying.
And that the Commonwealth didn't meet their burden on that.
They did not. But the problem is here, the defense did not get to present to the jury a full picture of who the only percipient witness was, somebody who could fabricate. And we have a law in Massachusetts that kind of, and our rules, look at this idea that somebody who's committed a felony or even a misdemeanor should have or may have their credibility impeached because if you've been convicted of a felony or a misdemeanor, that shows that you might not be honest, you might not have due regard for the laws of the state.
They're open, they're not convictions.
That is true, they are open, and so there are a few ways this could have been handled. And I go through them in my brief.
I'm going to just interrupt you for 1 second, if I may.
Please.
You don't think that the jury got a full picture that this were runaway kids who were engaging in transient drug-related activities, who were scamming and stealing without regard repeatedly, who were staying in motels and hotels using false IDs? You don't think all that got before the jury? Is that what I understand?
No, it did get before the jury, but it did not give them a full picture, and I'll tell you why. It's because it's the way the Commonwealth brought it in, right? It's the government who gets to bring in these bad acts of their witness as a way to show that, but he's telling the truth here. And that's not the case, right? He could have been lying, and to give a full picture of who this person was, yeah, you can bring, the government gets to say, yeah, well, he's committed all these things, but he's here truthfully testifying now. He is now under oath, right? That's the government's pitch to the jury. But the defense did not get to say, yeah, he might be reformed, but he also could still be lying. We have these...
Didn't they say that?
No, because they didn't really get to bring in the fact that he's, even after he left Massachusetts, this is somebody who engaged in some pretty serious crime in Nebraska. That gives a...
Did he? We don't know that he did, right? We know that there are allegations that he, I mean,
At
now,
that time,
now
there-
we know he did, obviously.
At that time, there were allegations, that's true. And so there were only 60 days between the time that he testified in Massachusetts and then pled guilty in Nebraska.
We didn't know that then.
No, I
right?
know we didn't.
But then the lawyer wouldn't have known that it's only going to be 60 days.
That's true. But again, these are things that can be coordinated through counsel to determine how far, what the timeline was for the Nebraska case. Again,
But this is all speculation because there wasn't a motion brought.
well, the motion was brought to at least bring up the Nebraska case. So had there been a conviction, you just have a question like, isn't it true that you're the person that pled guilty or convicted of this crime in Nebraska? But in this case, you can't just say that it's the conviction that is the only important determining factor for cross-examination, because the crimes had been committed, and then what I think you do is you look at the evidence. Or one way is to look at the evidence and determine, well, how strong is the Nebraska government's case against this young man? You look at the materials I submitted.
Who makes that determination, though? You're having a trial within a trial within a trial.
No, I don't think you do.
I think Judge Rayburn should look at the Nebraska evidence and say, you know what, this is a good case for the government, or this is a bad case for the government. That's how I'll decide if this comes in?
That's one way that a court could do it.
You have a case that says we do it that way?
No. And the only thing I'm trying to say is I'm trying to have you weigh the government's way of proceeding the way it did at trial versus the defendant's right to cross-examine and impeach this witness.
Well, ultimately,
Versus the
we're looking
victim's
at...
right.
Let me,
I'm sorry.
if I could just, one last point before I forget it. I may have forgotten it, but my case is so much weaker if there was any other evidence except this young man's testimony. I did transcribe the phone calls. You can look at those. They're nothing that's important for my case because, they just show that he knew the kid was under 15. The hotel receipts, as I said, they don't really add anything. His testimony is critical. And so when it's that important that we deal with the veracity of this one young person to give, I don't want it to be just so dismissed that other things came in and, the government did get a lot of their opportunity to show what kind of person this young man is. But it's those convictions. It's kind of what he was doing. He's still involved in this lifestyle.
The defense got to give a picture of what kind of young man this is. Not the government. The government perhaps also. But the defense got to show the lifestyle that this kid was living at the time of these offenses. I mean, the problem, I think, is the allegations in Nebraska are strictly allegations. He hasn't been proved guilty of anything. And so now aren't we risking playing on the emotions of the jurors because of the nature of the allegations? I mean, if the allegations had been shoplifting, would you feel so strongly about it?
No, this is the same. I would liken this to, for example, a bad acts instruction. We do it all the time. Just tell the jury, only use the information that you're given for this purpose and not for this nefarious or bad purpose. We do it all the time. Now, what really should have happened here was a frank discussion as to the timeline of the Nebraska case and whether the government or whether the case should be stayed pending the Nebraska charges. That's really what should have happened. And that's if trial counsel did one wrong thing besides not putting in the Nebraska materials into the ID record, it was that.
Was it your goal to just put those charges in Nebraska before the jury, or the allegations that support those charges?
As a defense attorney, I would try to get as much as I can, but the judge is the gatekeeper. So usually, if there had been a conviction, what you do is you say, as I said, aren't you the person that was convicted of this offense in this court? And sometimes judges will allow defense counsel to go a little bit further and talk a little bit about the facts. However, as the court was leery of trying the Nebraska case in the Massachusetts court, I don't think that's appropriate at all. But letting the jury know what's going on and why he's in custody and what's happened, what he's accused of, is important for making a determination of whether this young man is telling the truth, especially when his testimony is the only thing that is putting my client behind bars for a very lengthy time.
So look at it, he was charged with in Nebraska. He might be lying to you now. That's the theory.
That's it. That's a very good way to put it, yes.
I think that's unfair.
You think it's unfair?
At bottom, I do.
Again, go back into my brief and look at the importance of that courts have put to cross-examining a witness, especially when there is the only person who has who is giving testimony. The problem is again, none of us were in those rooms. We don't know exactly what happened. Everything is based upon this young man's credibility.
Were the two other runaways, were they around?
Around when?
Around at the time of trial. Could you have called them as witnesses?
They were not.
Your time's expired, but Justice Singh has questions.
Yes.
So ultimately, what we're reviewing is the judge's evidentiary ruling, right?
So you can look at it just as an evidentiary ruling in which you're looking at the discretion of the judge. However, this is a constitutional issue because his was the only, again, if this case is so much weaker if there's other evidence, but it's the young man's only evidence. So what we're talking about really is a constitutional issue, and I put in my brief the two steps that you're supposed to go through to review a judge's determination of limiting cross-examination, but it is a constitutional issue. It is dismissive of this case's import, I think, to just say this is a evidentiary determination based on the judge's discretion.
Thank you.
We have to leave it there, Attorney Benyon. Attorney Paris. So the folks in the courtroom know after this case, we're going to take about a 10-minute recess. Attorney Paris, when you're ready.
Thank you. Good morning, may it please the court. Molly Paris on behalf of the Commonwealth asking this court to affirm the defendant's convictions. In this case, Judge Rayburn properly foreclosed inquiry into the victim's pending criminal cases and custody status in Nebraska, where defense counsel failed to show how they were relevant to the victim's bias towards the Commonwealth or motive to lie. Starting off where counsel left off, this was a case where the victim's motive to lie and bias were extensively explored throughout trial. Judge Rayburn allowed cross-examination into the victim's the Noel Prost Boston case, the Attleboro charges.
Was it Noel Prost before he testified?
It was.
It was a dismissed case at that time.
It was, and trial counsel elicited testimony from the victim on cross-examination that before the victim had testified, he had spoken with the prosecutor, and the prosecutor had discussed dismissing those charges, and his attorney had relayed that information as well.
It wasn't a cooperation agreement in this case.
There was no cooperation agreement. The victim was always in custody, and again, had defense counsel wanted to use the Nebraska cases to show that the victim had a motive to lie at trial, he would have needed to show a material change in the victim's testimony from the time of Nebraska until the time of trial, and he made no showing on that issue, and that's why Judge Rayburn was well within her discretion to rule as she did. Also, defense counsel conceded at the motion to eliminate hearing that because the Nebraska incidents post-dated the victim's report of abuse in March of 2021, they had no bearing as to his motive to lie to police in reporting.
Did counsel seek to introduce the Nebraska material for some other purpose besides motive to lie?
That was not clear on the record, Your Honor. It was just offered towards motive to lie or bias. The argument now that it could have been admitted as prior bad acts evidence was not raised below, but again, that would have been still reviewed under the 403 balancing test, and here where Judge Rayburn allowed extensive exploration into the victim's credibility, and the victim, in fact, was forthright in acknowledging his wrongdoings as to the Boston charges, as to the Attleboro charges, and as to lying to a train conductor, as well as engaging in credit card fraud. So that was a proper decision on Judge Rayburn's part. And just briefly turning to the ineffective assistance of counsel claims, those are raised for the first time on direct appeal. There was no motion for a new trial, and on this record, it's not clear. The factual basis of those claims is not clear. There was no mention of a motion to stay or that there would be one. There was no discussion as to when the Nebraska charges would have resolved. And even if there had been discussion as to a motion to stay, any possible motion to stay would have been predicated on the outcome of that Nebraska case, which was unknown at the time. And again, just briefly, as to the Nebraska documents, it's unclear, based on the trial record, what would have been offered, and based on Judge Rayburn's ruling, it made sense why counsel would not have brought forward those documents. So unless the court has any further questions, I'll rest on my brief.
Seeing none, we'll take the rest of your argument on your brief. Counsel, thank you both very much. The case is submitted. The court will take a brief recess, and we'll return in about 10 minutes to hear the last three cases.
All rise. seated.
Before I call the next case, I just want to make sure the department's going to use 8 minutes and child's counsel is going to use 7.
Yes.
And have we tested the device? Are
Yes,
you
Your
good
Honor,
to
thank you
go?
very much.
Okay, so our next case is the Department of Children and Families and others versus Mother and Another, docket 24P919. I need to remind counsel that this case is impounded, so we will not be using any names. With that, Attorney DeFeo, when you're ready.
Thank you, Your Honor. Morning, Your Honor. Jennifer DeFeo. I represent the appellant mother. We are requesting that this court vacate the decree that granted permanent custody to the Department of Children and Families. As this court knows, the case law is very clear that in order for a judge to do that, there had to have been clear and convincing evidence that the mother was unable to take care of the child in the capacity that the child was at the time of trial. On day 2 of the trial, Justice Tan made it very clear that the trial was rife with speculation, and this court needs to review that because speculation or conjecture cannot be the basis for granting custody to the department. Justice Tan, as well as the attorneys, I believe, and myself when I was writing the brief, was really distracted by a lot of the nuances in this case, such as, did they know how to clean the G-tube? Did they know how to use the Hoyer lift? But when it comes down, yes, Justice Desmond.
So you say that's a nuance. I mean, doesn't that kind of speak to the heart of the case? I mean, we have a child who has had a traumatic brain injury amongst other injuries, who seems to need round-the-clock care for all essentials, feeding, hygiene, all of these things. And it seems like mom doesn't know anything about any of them.
So that's exactly the point, Your Honor.
Doesn't know how to flush the G-tube, doesn't know how to brush the teeth, doesn't know how often she eats.
When a child such as this is...
So when you say mom can provide minimal care, is that the...
So it isn't even that.
What does that mean?
So she doesn't even have to provide minimal care.
But I think you said that, though, so I'm wondering what that means.
So minimal care would be to, in this instance, maybe to follow the rules of the facility. The facility itself is the primary caretaker because they provide 24/7 care. Mother doesn't ever have to change the
But
diaper.
isn't that the problem?
Yeah, but doesn't we...
Because isn't the problem that the child needs to be in DCF custody to get care at this facility?
That is absolutely untrue. There is nothing conclusively that showed that. Not even a fair preponderance of the evidence, Your Honor, that showed that. Dr. Wu, who sort of brought this all up, said, I believe that she can only go if she's in DCF care. DCF said, I don't know. No one from Seven Hills came and said she has to be in DCF care. No one from Mass Health came and said, well, we'll pay, but only if she's in DCF care. That required at minimum a layperson testimony that that was actually true, if not an expert testimony, because that was a huge part of this case. And there's no doubt.
What if the judge's finding, instead of saying this was okay, so you're saying what's not supported is that the child had to be in DCF custody to be in the facility? You're saying that's not supported by the record?
It is not, Your Honor.
And you're also saying what's not supported by the record is that this was the only facility that could provide this kind of care in Massachusetts?
That is correct, Your Honor. There are 2 other ones that do accept it. Evergreen Center in Milford and Crystal Springs in Astronaut.
Is that in the record?
It isn't, Your Honor, but they did talk about a specific school that couldn't handle. But I think the other question, Your Honor, if you're bringing it up in that way, is what would have happened to this child had DCF not been involved? And I think the answer is clear. The same as what would have happened to any other child who was tragically injured, was on a G-tube, had a traumatic brain injury. She would have had to have care from somewhere. Spalding itself, their doctor said, we can't just release her to no one. DCF said, Spalding can't just release her to no one. So what if DCF had not been involved? Are you saying that the parent whose child was hit by a car that DCF wasn't involved in, that DCF would take custody? No, I mean, that doesn't even make sense. The fact that this child needs full-time residential care means that the facility takes care of the day-to-day things. The fact that some people believe Seven Hills is the only facility that can do that was not shown by a fair preponderance of the evidence.
But there are no other places offered in the briefs, right? Did anybody suggest some other place other than possibly one in New Hampshire? I think Wu says, I think that there was another family who went to a place in New Hampshire and was able to take advantage of the services there. But I didn't see any other offered or suggested place of care for mom. The goal is reunification still, isn't it?
This child is never going to
Is the
leave.
goal still reunification?
It isn't, because DCF is not doing anything that will allow it.
The goal is, I believe the goal is still reunification. You're saying it's not?
I'm saying that there's smoke and mirrors.
I'm asking
saying,
you, is the goal still reunification?
yes, mother's rights have not been terminated. So again, why should her constitutional rights be stripped because DCF didn't prove its evidence by clear and convincing information? It didn't even have a fair preponderance of the evidence, Your Honor, that this facility only takes DCF cases. They speculated, and speculation and conjecture is not acceptable to show this.
So let's just, for the purpose of discussion, assume that we're not persuaded by that argument. How is mom fit?
Mom is fit because the day-to-day activities that have to be taken for this child are 100% cared for by the facility. And even Dr. Wu herself said, Your Honor,
Hold on. So therefore, I want to follow on. So therefore, because mom doesn't have to do anything, she's as good as anybody else to parent this kid.
absolutely, Your Honor. So if my
That's
child,
the
God
feeling?
forbid, had been hit by a car, DCF would not have come in and said, okay, your child was hit by a car, she has a traumatic brain injury, we're going to take custody. It doesn't happen that way, Your Honor.
I understand,
Because
but we're
the
not talking
gaps-
about your child. We're talking about a family who has a long history with DCF, who have 5 children, who have 2 parents who don't work, who were brought to the attention of DCF as a result of some criminal conduct with the kids. So we're not talking apples to apples.
We are, Your Honor, because the apples to apples is fitness. It is, was the mother fit to parent this child at the time of the trial? And she was, because she agreed
What points to fitness?
that she would keep the child in the long-term residential program as stated by her team. And the fact, Your Honor, is the sons were returned to mother's care in August, and DCF said, more likely than not, other than for this accident, so would have been the daughter.
I get it,
So,
but the accident's a big thing. I get it.
so if somebody who wasn't involved with DCF, child, had that happen, is it this court's suggestion that they would have a 51A filed against them because their child suffered a traumatic brain injury through no fault of their own? Your Honor, that's what we have to look
Justice
at.
Desmond's point, though, counsel, this family was involved with DCF because the parents were shoplifting and blamed it on the children. This wasn't because of this horrific accident that this young girl was involved in. So I'm going to repeat what Justice Desmond said. It is not apples to apples. I want you to give us the best case you have that is similar to this fact pattern where either the appeals court or the SJC concluded that it was error to place the child in the care of the department without terminating because the parents didn't need to do anything because the facility could do everything. What's your best case?
There isn't one. But I will state, Your Honor, that care and protection of Laurent, which I think has a...
What, Lauren?
Laurent, Laurent, where this court found that it was a lot of just smoke and long on smoke and short on fire. We had a mother who had significant cognitive issues. We had a child who had significant issues. And what they stated is, yes, she has gaps in her knowledge. She has deficiencies in her parenting. But what it comes down to isn't, is there some risk of harm, but is it such a great risk of harm that it amounts to grievous shortcomings or handicaps? And what it all comes down to, Your Honor, is the key question is, would mother have agreed to keep the child in long-term residential care based on the advice of her team? And absolutely, she testified repeatedly that she would, and the judge made findings that she would. So where is the unfitness? She does not have to change this child's diaper. She doesn't have to do anything. But what she was deprived of, and this is what's really important, is she was deprived of the right to visit her child when she wants. She was deprived of the right to make medical decisions, even if
she
that...
didn't show up for some of the visits when she was provided with them?
She had other children at home, so she did regularly visit.
Wasn't she invited to stay overnight to learn more about the care?
So, Your Honor, again, that's a gap in her knowledge, but she doesn't have to take.
Hold on. Wasn't she invited to stay overnight to learn more about the child's care? That calls for yes or no?
Yes,
Okay, and she elected not to do that, right?
that is correct. But that's,
And
even
do we
Judge,
know why the parents, why did father learn about the G-tube?
mother struggled with the fact that 5 months her daughter had been in the hospital. 5 months to the day she testified just about, her daughter almost died.
Why did
So-
father learn about the G-tube?
Because he wanted to, because they asked him
For
to.
no other reason?
I'm sure there are a lot of other reasons, Your Honor, but what it comes down to is when this child is in long-term residential care, 24 hours a day, dad doesn't need to change her D-tube. The parents don't need to brush her teeth. They don't even need to know how to
Why did
get
he
her
learn
in the
about it?
shower.
So why did he learn about it then?
Because he wanted to. Just like he sits by her side and talks to her, because that's what he wanted to do, Your Honor.
Mother didn't want to do that.
Mother would have done it had the child been released to home. But Dr. Wu made it very clear, this child
How could the
wasn't
child
going
be
home.
released to home if mom doesn't know how to feed him?
The child had no possibility, Your Honor, no possibility. There is nothing in this record, there's nothing in Dr. Wu's expert testimony as a residential care specialist that even suggested that this child had any possibility of going home anytime soon. Indeed, and please, may I quote Dr. Wu? Because Dr. Wu said, and I think this is pretty important, is she said that even if the parents were to go through whatever training or discharge procedures she wanted them to go through, and their home was appropriate, child would still require residential care. She was not ready to go home at the time of trial. So, Your Honor, there were other options. For example, Your Honor, they did not have to take away these parents' custodial rights. They could have had them enter into a voluntary placement agreement. That would have allowed the child to stay in DCF care for the purposes of Seven Hills, but would have allowed the parents to be able to continue to visit, to allow them to participate in the medical decisions, Your Honor, even if it's just to say, I'm putting this in God's hand, and you, as her caretaker, have the right to make this decision for me. They still have the right to be informed. And I think...
Did the mother engage with the care providers at
Yes.
Seven Hills?
I can talk about Seven Hills. It's outside of the record because nothing was discussed on the record about Seven Hills. So she was still in Spalding at the time Mom and Dad
Did the
testified.
mother engage with the care providers at Spalding?
Absolutely, and she
To what
testified.
extent?
She talked to them regularly. She talked to the nurses and the nurse care practitioners, my apologies. So one of the things that this court has to recognize,
She's talking about the care of the child?
she's talking about her child, whether it's what is she having for meds, what is she being fed through her G-tube. These are things that they have no control over yet, Your Honor, because the 24-hour-a-day care,
I understand.
they're the
I understand.
provider.
I got that point. Did the child know how many medications, did mom know how many medications the child was taking?
Yes, she did. And she knew how the child received it.
I didn't see that in the record. Where in the record do you point to?
Let's see. I don't know that I can pull that off, but I can
Well,
definitely
just
send a letter.
Take a moment, so I can
I don't
see.
have the transcript with me, Your Honor.
Well,
I don't. But I will tell you that Mother said that she has between 5 to 7 medications, and that the medications are given to her through the G-tube, and that after the medications were administered, the G-tube had to be cleaned. And that's, again, not something that she herself would have to do while this child is in 24-hour-a-day care. And I think that it's important for this court to note that at the very end of the trial, Father made it clear that they were being treated like, at the end of the trial, Your Honor, he stood up and he said to the judge that they had been denied their right to see their daughter from the November testimony till then, and that he himself was devastated over this fact, and they shouldn't have had their parenting time even subject to DCF's whim. What happened is, Your
Father
Honor...
elected not to appeal?
Excuse me?
Father elected not to appeal?
I do not know why his trial counsel did not. Father, and again, it's outside of the record, but he absolutely thought the case had been appealed because I've met with him. But I think that this court has to understand that
Judge Tan recognized the dilemma. The dilemma is what would happen to the child if she wasn't in Seven Hills. But not having Seven Hills supposedly available to the mother does not make mother unfit. It's more of a public policy issue where shame on this state for not having somewhere else. And it's allowing an inappropriate comparison between DCF as a substitute caretaker providing better opportunities than the parent. But all in the end, the gaps in mother's knowledge don't matter at this time because this child may never leave this hospital, which would be devastating. Obviously, she's only 15 or 16 years old at this time. And I do see my time is up if there are no further
You
questions.
just checked.
Did one of the medical providers say that the daughter may never leave?
Absolutely.
The residential facility?
Yes, Justice Desmond, Dr. Wu did. She said, and mother acknowledged that, by the way. Mother acknowledged that this child may never leave. And then she said, if that's God's plan, that's God's plan. But if she doesn't get to leave, she's okay with that, and she will keep her child in long-term care.
You will
But
have
she-
to leave it there, counsel.
Okay, thank you.
You've answered Justice Desmond's question. Next, we will hear from the department, Attorney Gallup, with 8 minutes.
Good morning, may it please the court. Julie Gallup on behalf of the Department of Children and Families. The department is asking for this court to affirm the judgment committing the child to the department's permanent custody and finding mother unfit, as there was sufficient evidence of her unfitness. Now, I think there was an important question that was asked a few times, was what would have happened if DCF was not involved? And I think that the answer to that question goes in part to why the judge did find mother unfit, which was she was unable to have conversations with both the department and the providers about the child's care, to develop an understanding of how to, what are her needs, her specialized medical needs, and then to also develop a plan for meeting those needs long term. The evidence presented demonstrated there was a meeting in October, shortly after child transitioned to Spalding, that mother did not attend, and that father left at the point when the providers did start speaking about the child's long-term care needs. So part of the unfitness for mother was her inability to understand and to plan for how to meet those needs.
One of the findings was that mother understood that she needed a residential placement, and she stated that she would cooperate with that, and the judge found that, correct?
So, sorry, can you repeat that question?
The mother stated that she understood that her child needed a residential placement and that she would cooperate with that, and the judge found that.
The judge did find that, but
Again, in terms of the mother's ability to do all of this for the daughter, or to understand, is that really relevant, since the point was the child was going to be in a residential facility and the mother said that she would cooperate with that, and the judge found that?
So when Dr. Wu testified, which I believe was in January, the last trial dates, after the child had transitioned to Seven Hills, what I recall from Dr. Wu's testimony was that most patients at Spalding are unable to transition from a hospital-based place like Spalding directly to a home setting, and that most patients will need some type of long-term care in the interim before they can transition home. Dr. Wu also testified that it was unknown what child's progress would be at that point, and that while she had made some progress at Spalding, that was why they kept her there for a little bit longer, that we don't know what the plan is, or what the outcome could be. Therefore, it was incumbent on everyone to have conversations with the providers to determine, is she making progress? Can she transition to this type of setting? Can she not? And mother was unable to have those meetings, to have those conversations with the department. I believe there was a finding that, I don't know if it was a finding, but the social worker testified that in the home visits with the parents, whenever the subject of child's, what are we going to do, future planning for her, to care for her, the parents kind of, put an end to the conversation. They were unable to have those plans. So the question again kind of, I would say, to look back on, what if DCF was not involved? The parents would need to have conversations with providers. to get an understanding about what the child's specialized needs are and how are we going to meet them in this moment and then moving forward. And that is part of the unfitness.
You say part of the unfitness. Is that the whole unfitness?
Well, I mean, it is the whole unfitness, but also just to be more specific, though.
The idea that could be considered a grievous shortcoming of a parent, that they're having difficulty sort of grappling with the future of their child. I mean, it doesn't seem to compare to other cases where we talk about a grievous shortcoming of a parent.
So the judge made several findings about what those specialized needs are. Basically, child relies on other people just to exist in the world. You know, she has specialized mobility needs, limited communication skills. She relies on others to manage her hygiene needs, and she has a G-tube for both medication and nutrition. So, and there is case law that said, you know, has affirmed an unfitness finding where a child does have substantial needs that require extraordinary attention from the caregiver, and the caregiver has an inability or unwillingness to learn how to meet those needs. And that's the point, is where we don't know what the child, you know, we need to have a conversation with the providers to determine where are we moving forward to. If you don't even have a basic understanding of like where the child is at that point, how are you able to then plan for the future?
I want to address Mother's Counsel's reference to the Laurent case.
I did write that down.
I mean, Laurent does talk about you don't have to wait for tragedy to happen before the state intervenes, but it also talks a bit about, to Justice Singh's point, grievous shortcomings. So I think you addressed it in your brief in passing. Is there anything you wanted to add?
I mean, I guess I would say that I believe in the judge's conclusions of law, the judge kind of, you know, spoke about how a lack of an understanding of what the child's needs are would suggest then that the parents are not going to be able to meet those needs, you know, specifically, I think with like hygiene and feeding, you know, we don't want to have to wait for something horrible to happen if you don't understand how you're going to, you know, take care of this child. I think,
And so Laurent says that can't be based on speculation, and I think the question that's being raised is, isn't it speculative because we just don't know what's going to happen if the child were to return to her parents?
At the time of trial, where the parents were unable to have a conversation or even develop a plan, present a plan, I don't believe it's speculation. You know, the parents needed to. Now, I don't want to put this on the parents, but they were offered opportunities to learn more about what, you know, caring for the child looks like in a 24-hour setting. They were offered opportunities to stay overnight. You know,
was it true that at the time of trial they were living on the 3rd floor without an elevator? It was a walk-up, and that they were looking for a first-floor apartment?
That was the finding. Yes, that they were living, that they had not moved, but they were. You know, mother testified they were looking. I don't recall if I think there may have been some testimony. She didn't necessarily understand that, like, the type of shower was needed, but at the time of trial, they were living on the 3rd floor.
I know this is outside the record, but just yes or no, has there been an R&R in this case?
No, there is not.
Neither parent works?
That was the evidence, that neither parent works, that they rely on government assistance.
And do we know whether or not either mom has any disability?
I don't believe there was any evidence presented that, I mean, I think that there was evidence that there was SSI and SSDI income, but it wasn't established which parent received that and for what reason.
The judge's decision read as if everything comes down to this child needing significant services, and there's only one place to get the services, and that place requires the child to be in DCF custody. So sort of a result-oriented kind of decision. It has to be this way in order for her to get the services. And that doesn't seem like an appropriate way to determine a parent's fitness.
So those were the findings. Dr. Wu's testimony was, I'd say, a little bit more, unclear. Dr. Wu said, I understand other patients have gone to a program in New Hampshire. I'm not completely familiar with what's available, and that would be like our administrative staff would be having those conversations with the parents were this child not in the department's custody. So again, I think that goes back to, an absent where the parents weren't having conversations with the providers about what the options are. And mom's testimony was like, well, I can call Mass Health,
So whose burden was it to have these alternatives out there? Was it DCF?
No, I mean, the department bears the burden of demonstrating unfitness. The parents do not need to, prove that they're fit, but I would argue that they need to show some type of parental responsibility of, this is, I'm taking this initiative. I don't want my child in the department's care or custody. I looked at these programs.
Did anyone challenge at trial that testimony that this facility only takes DCF clients?
I think there was, both the social worker and Dr. Wu were questioned, I believe, by all of the parties on this issue. And I would say that, from my perspective, Dr. Wu, kind of didn't really know, but decided to land on, this is my understanding. And again, I think, I don't recall the social worker. I think that it presented as this was the only option, but I guess we don't really know because the parents, didn't finish that meeting in October where they could have had more information about, what are we looking at.
I believe Justice Desmond. Nope. All right, we will next hear from Attorney Ferrigno on behalf of the child.
Good morning. May it please the court, my name is Sandra Ferrigno and I represent the child. We are requesting that this court affirm the decree issued by the lower court, finding mother unfit and committing child to the permanent custody of the department. Just to point to a few things that my sisters had pointed out. With respect to, as we know from the record, mother had a difficult time and was unable to learn about the things that she needed to learn to care for her child. Her goal had been reunification. The goal was reunification at trial, and that is what mom wanted. But mother failed to avail herself of the opportunities that she needed, that she had to learn about things like how to work with the G-tube, how to use the Hoyer lift, how to take care of her overnight. Parents did not attend the overnight opportunity that they had to learn about her care.
Counsel, are you familiar with adoption of Flavia that this court issued in 2024?
I am vaguely familiar with that case, Your Honor, yes.
I want to ask you, because we held in that case that there was sufficient evidence of unfitness where the parents, I'm going to quote, could not articulate a realistic plan, end quote, for meeting, quote, the complex emotional and physical needs, end quote, of the children. So would you say that a child's needs are complex and both emotionally and physically?
They are, yes.
So then the question is, could the parents articulate a realistic plan for meeting those needs? What do you say about that?
They could not, and I think that the department really tried.
And that is sufficient for a finding of unfitness, to Justice Singh's questions to DCF counsel earlier.
It is, Your Honor. The department, on their monthly visits, they tried to engage the parents in conversations about what long-term planning would look like for the child, and they set a very clear boundary that we would talk about this other child that they had involved with the department, but not about this particular child. Dr. Wu testified that in the 4 months that this child was at Spalding, she had never had one conversation with mother about anything. She had never met her. She only had conversations with father. Mother did not attend the information meeting at the beginning in October when the child was first placed there, and she had a very difficult time speaking with anyone other than the nurses when she was able to attend. At the time of trial, she testified she hadn't seen her daughter in 5 days, so she had not been visiting. I also want to point out that during Mom's testimony about allowing the child to remain at Spalding or long-term care, Mother specifically says on page 34 of the testimony that she would allow the child to remain at a long-term care facility temporarily, but not long-term, no. That was her quote, that her plan was to have her child placed back at home with her. And if that were the case, which the department was working towards, she would have to know how to properly and safely care for this child. So by being unable to have those conversations with the department or with the medical professionals, she really showed that she would not be able to make good long-term or short-term decisions for her child if she had retained custody. And that would create unsafe expectations for the child if she were to be returned home.
What, if anything, are we to take from, it's my understanding that the child is nonverbal, is that
Correct.
accurate?
Yes.
But Mom seems to say that she does talk to the child, and the child can say, "Hi, Mom," and some other short words. What, if anything, are we supposed to take from that?
I think that there has been in this record, the record is clear that there is a very distinct difference between what the parents believe the child is able to do and what the medical professionals and what Dr. Wu testified at trial about what the child could actually do. Mother testified that she did hear the child say, "Hi, Mom." Dr. Wu testified distinctly that the child is nonverbal. Not only is she not able to speak, but she's often not able to understand anything that is going on around her, that she is able to make facial expressions based on loud noises or bright lights, but that she's not able to understand really anything that's going on. And it just goes to your point, Your Honor, that Mother's just not, she's very hopeful. This is a very tragic and very sad case, and anyone would want that for their child, but the evidence does not point to the child being able to do any of the things that Mom says she can do.
Mom said she could grip a ball.
Correct.
And the doctor said no.
She cannot. She had a disorder, movement disorder, so she has involuntary movements, but she's not able to grip any ball or hold a pen or pencil, I think was what one of the parents testified that they thought the child could do, and she's just not able to do those things. So that would create a safety issue with respect to whether or not they were going to have her back.
And she wears diapers?
She does.
And they need to be cleaned or changed periodically throughout the night?
That is correct. That is correct. So, and there was testimony about that Mother had not had the opportunity or availed herself of the opportunities to do that. She also, her overnight care seems to be really important with respect to preventing pressure sores and things like that. And that was
moved every 2 hours.
Every 2 hours. And that is why the hospital wanted parents to come to the hospital to observe and learn all of these things, because it would possibly, if they were able to do these things and because they could take turns, they don't work, as Your Honor mentioned, they would be able to possibly come up with some type of a plan. But unfortunately, Mother was unable to come up with any type of a plan other than, we can do it, we'll manage. But she didn't really have the understanding of just the intensive care that the child required. And that was the concern of the doctor at trial. If there are no other questions, I would rest on my brief.
I don't see any. Thank you very much.
Thank you, Your Honor.
Counsel, this is a very sad and tragic case. You all did an excellent job in presenting it. It is now under advisement. Thank you. Parties on the next two cases can set up, and as you come up, what we're going to do is we're going to hear them separately, because each party, although they're same parties in both cases, on one instance they're an appellant, and on one case they're an appellee. So the first case we're going to hear is the contempt, which would mean, and I mean no disrespect by using first names, but just to clarify, KRIS will be the appellant in the first case. So I'm going to have KRIS sit at that table for the duration of the hearing. AYESHA's counsel at the appellee bench for all of the hearings. What I intend to do is to hear each case separately. So the first case is confined to the contempt issue, and that is where KRIS is the appellant. And the second case that we will call separately is the judgment in the underlying case where AYESHA is the appellant. Does that make sense to both of you? I can't imagine you're going to need all of your time on both cases, but I'm going to just handle it that way to make sure that we get both cases in cleanly. So the first case I'm going to call is AYESHA Alexov, I'm sorry if I've mispronounced that, versus KRIS Alexov and another, docket number 24P583. Mr. Alexov, you may proceed.
Thank you, Judge. KRIS Alexov, pro se, and on behalf of 28 Bradford Street, LLC.
You are pro se, but you are a licensed attorney in Massachusetts, so you are held to the same standards.
You're right, Judge. I'm just trying to be clear. Thank you. The contempt order fails because I guess, plaintiff lost in all of her claims. All of her claims were dismissed at trial after a jury, and in this case, that means she is no longer an aggrieved party. The contempt order also fails because the underlying foreclosure sale, which is what I assume the judge was basing the ability to pay on, never closed. So there's no money to pay that judgment, and as part of a contempt judgment, there has to be a finding on ability to pay, and that was never done in this case.
Isn't the purpose of a contempt twofold? One of the purposes is to coerce compliance.
That is correct, Judge. That is one of the purposes.
So why couldn't the contempt judgment itself stand? Putting aside the monetary orders, but the contempt judgment itself could stand based on the judge's finding that you were not in compliance with the payments, and he so found, and therefore the contempt judgment can stand.
I think if you take away the monetary issue of it, then there is an argument to be made there. But additionally, this was on a preliminary injunction, a preliminary matter. It's not a final injunction.
Happens all the time.
Sure, and it does, Judge. But we're at a point where there's been a dismissal and there's no longer an aggrieved party where the underlying order itself should fail because all of the underlying claims were dismissed.
But if you agree that the contempt purpose, one of the purposes is to coerce compliance, hypothetically, the contempt judgment could stand, the attorney's fees could stand because the statute says that the judge has permission to enter attorney's fees if it's to coerce, and the escrow account could stand because that was used to pay or presumably to pay the foreclosure deficit. I guess the only question I would have is what the $200,000 was for.
I have the same question, Judge. There was no clear indication of where that money came from and how it compensated the plaintiff.
What is your understanding of the purpose of the order of $200,000? What was the $200,000?
My understanding was that there was to...
That what?
I honestly don't know where that number came from. It was less than counsel asked for and more than I asked for. I didn't see a clear indication of how that...
It's actually exactly what he asked for. On page 14 of his proposed order, he asked that you would be ordered to pay punitive damages in the amount of $200,000 and attorney's fees in the amount of $25,000. That's in his docket on page 14 of his proposed order on contempt. So the judge ordered exactly what counsel for the plaintiff asked for.
Sure. And I mean, that's not how I remember it, but if you're saying it says that, then I agree with you. But there's nothing so punitive here to require a payment of $200,000. That seems like an incredible penalty for a situation where the plaintiff, in this case, was never even harmed. She still lives in a house rent-free. She's still...
we can't hear about what's happened since the trial, okay?
Sure, and I understand that, Judge. But in this case, I think the law is pretty clear. Where a plaintiff fails on her underlying claim, she can't be compensated for an injury that a jury is going to have to make a final decision on. And I think the word in place makes that pretty clear.
So you said that the $200,000 was more than what you had suggested.
Yes, I didn't think...
What did you suggest?
I didn't think there should be a penalty, Judge, because I believe that in this case, I attempted to comply with the order, but at the time when compliance, I tried to comply. The bank wouldn't accept any more than money than I had in my bank account. I went to...
It seems like, I'll be honest, that you have a lot of excuses as to why there was noncompliance. It seems like it's everybody else's fault. The bank didn't do this, the mother didn't do this, lots of different reasons. Yet, on the papers, you appear very orderly and organized. It seems as though you were running these properties and doing accountings on the properties and what have you. Did you ever come into court and say, hey, judge, I can't comply?
Not on my own initiative, Judge.
Why not?
It just didn't happen. I don't have a good reason. I'm not going to give you an excuse.
So you're not claiming that the order was not clear?
I am also claiming it's not clear. It was originally one order, and then it said you had to make payments at the time when
after the clarification, was it clear after the clarification?
Pardon me?
I understand that there was an order, and then the judge clarified the order. Was it clear then?
Yes, and that's when I spoke to the Bank of America, and they were asking for a lump sum payment to bring the mortgage due, and I didn't have that amount of money to pay.
Okay, so you're stating that the non-compliance was your inability to comply.
I couldn't pay it, Judge. I didn't have the money.
I have two ancillary questions for you. You talk about waste and that there's the mold issue and whatnot, but I didn't see that in the actual contempt judgment.
In the contempt judgment, I believe there was some talk about that in the
history, but
sure.
I didn't read the judge as having ordered you to do something relative to the waste issue. Am I wrong?
You're not wrong, Judge. You're not wrong.
And do we know, is it in the record, what happened with the insurance proceeds from the tree that fell in the house?
I put them in to put in a new roof on the building.
So the proceeds were used to replace the roof?
Correct.
And that's in the record?
It's somewhere in the transcripts.
Okay. Do you have anything else on the contempt?
Other than, this is a clear case where all of the claims were dismissed and the compensating the plaintiff for failing to make any of her claims stick, it would be both unjust and frankly, the order, because now the foreclosure sale hasn't gone forward, that money, which was dependent on the sale happening, is not there, and therefore there hasn't been a showing of ability to pay the actual judgment.
Okay, on the contempt, we will take the rest of your arguments on the brief. And Attorney Chapdelaine, we will hear from you on the contempt issue only.
Good morning. May it please the court, Mark Chapdelaine on behalf of AYESHA Alexov. On just the issue of the contempt, Mr. Alexov did not meet his burden to show clear error on the findings of fact of Judge Sisesky.
I'd like to focus on the $200,000, if we could, because in your proposed order, you asked that the defendant be ordered to pay, quote, punitive damages in the amount of $200,000 and attorney's fees of $25,000. And I've read the memorandum of decision multiple times. The judge does not explain the $200,000. And so can you tell me what the $200,000 was for?
It's for, in part, to ensure that Mrs. Alexov has a place to live. And second is the punitive nature of it. This is her home that has been, at that time, was in constant threat of foreclosure.
I was afraid you were going to say that, and I'll tell you why. Neither one of you cited this case, but there's an SJC case. It's 381 Mass 208, Manchester versus the Department of Environmental Quality Engineering, that says punitive fines cannot be imposed in a civil contempt hearing. Where a fine is imposed, it cannot exceed the actual loss to the complainant caused by the violation of the order, plus reasonable expenses for the contempt proceeding. So I think if we uphold the contempt finding, you get your attorney's fees. I think that the amount held in escrow for the foreclosure sale, you get. But I don't see how you get the $200,000. You categorize it as punitive in your pleadings. You've honestly come before us today and said that was what it's for, but the SJC says you can't do that.
Well, the other part of it is that it's her home. So because the foreclosure was, the preliminary injunction was essentially ignored, despite multiple court appearances. I believe there was...
What was the $200,000 going to do for her home?
Give her a place to live. well,
For relocation expenses?
yes.
Where does the judge say that? Where do you plead that?
Well, it was in the facts that were argued at the contempt trial.
You didn't ask for relocation expenses, you asked for punitive damages.
Correct.
Pay the 200?
The house sale is still in the process of being litigated by the winning party of the foreclosure auction.
So the answer is he has not paid the 200.
He has not paid the $200,000, nor has he he hasn't paid anything.
Even if the $200,000 figure is not supported, that doesn't mean the contempt finding is not supported, right?
Agreed. And, the importance of following a court order, and certainly having the ability to come to the court and say, I need a stay of this order, or I need a modification of this order. That was well within Attorney Aleksov's purview, and he chose not to do that. We were before the court, I believe, about 6 times on these issues, with multiple contempts being filed, with multiple pre-contempt hearings before the court. A lot of this was during COVID, but Judge Wilkins' order was clear and unambiguous to start, and once we filed the first contempt, he made it abundantly clear of what the order was. And still, when we get to Judge Sisiski for this final contempt, we're still hearing that it's ambiguous and unclear.
Well, what about ability to pay? Was that supported?
The ability to pay issue is, the issue with that is that Attorney Alexov on the stand was never able to show who he spoke to, what letters he sent, who from the bank he contacted, when he contacted the bank, any steps he took whatsoever to try to make this right. And as an attorney or as a citizen, I mean, he could have certainly picked up the phone, contacted the bank, and he could have written down who he spoke to, when he spoke to them, and kept track of that. He didn't do any of those things. Instead, he said, I tried. Well, how did you try? I don't know how I tried. I don't remember.
I'm sorry, did you finish your answer?
Yes.
Was there record evidence that monies were coming in from the properties and that Attorney Alexov was, I don't want to say living lavishly, but traveling? I think he went to Hawaii. He may have gone to some other place, Chicago perhaps. Was all that in the record?
Significant evidence was in the record. His travel schedule, the accounting of what was coming in on the rents. He had actually taken over one of the extra apartments. So he had two of the, I think it was a 6-family, 2 of the 6 apartments he then took over, adding to the waste, adding to the inability to pay. So it was really a self-created inability to pay in a lot of ways. There was certainly travel to Chicago. I think it was Hawaii. There was some other trips in there too. And as a consequence, these mortgages, and these were small mortgages. I mean, this was a $45,000 mortgage on a property that was worth, 15 times that amount. The fact that these weren't able to pay, or the inability to pay, is now a defense. It was a self-created defense. And it was created by his own actions, the inability to pay. If he simply...
Taking over that apartment, that reduced his income.
It's another $1,000 or so of money that wasn't available for the bank. And this was a second mortgage that Bank of America had.
Was there any evidence of any effort to pay anything?
None. And it was put on a silver platter at the contempt trial of what, if anything, did you do, and there was nothing. There was nothing that was done.
I know you raised waste, but I didn't see the judge, he addressed it in the sort of the factual background, but I didn't see any orders relative to waste. Do you agree with that?
Agreed.
I don't see any other questions on the contempt.
I'll rest on my
Okay.
brief
But I'm
on
not
that.
going to make you switch tables, so why don't we go off the record on this one, and why don't you stay where you are, because you are the appellant in the next case, but I just want to give the timekeeper a moment to switch the clock over, and then I will call the next case with the docket number. So our final case this morning is AYESHA Alexov versus KRIS Alexov and another. This one is docket number 24P848. And on this case, Mr. Chapdelaine, you are the appellant, so you may proceed.
Thank you. Mark Chapdelaine, on behalf of AYESHA Alexov, may it please the court. We are asking that this court find that clear error was committed by the trial judge when he found that the initial verdict slip that was returned by the jury was inconsistent. The case law is clear under the Pal-Riwala decision, I think it's cited in page 23 of my brief, that it's not the duty to find some measure that makes it inconsistent, but rather find a reasonable explanation of why it's consistent. So here we're left with this decision, this verdict slip, and the first count asks...
Back to the verdict slip?
In part, yes. It was a collaborative effort, though, the verdict slip. I wasn't... in the end, I was content with the verdict slip at trial.
You didn't see the potential for an inherent inconsistency when the special questions went to the jury?
I still don't. And the reason for that is because Clary makes it clear that once the burden shifts, as it did here, the elements do essentially change. I mean, so here we start with undue influence, and the question is whether there's a natural disposition. That issue, once we get to that there's a fiduciary duty in place on Part 3, that issue no longer matters because, as it states in Clary on page 293, if I may, once a fiduciary relationship is established, the fiduciary who benefits in that relationship must show that he has fulfilled his duty. Although family relations and the fact that within such relationships, gifts or other acts of generosity and natural and to be expected may serve as evidence of propriety, they do not shift the burden back to the contestant. The fiduciary can take precautions to ensure that proof exists that the transaction was fair and that his principal was fully informed, and he is in the best position after the transaction to explain and justify it. It is his burden to do so, whether or not he is a family member or in another close relationship.
But you didn't bring a breach of fiduciary claim.
There's no requirement to bring a separate claim. It's under undue influence once a fiduciary is found. That's when the burden shifts. So we go back to the...
Belts and suspenders. Why wouldn't you bring... I mean, your claim is really that he abused his durable power of attorney in these deeds. That is classic of a claim of breach of fiduciary duty as I can think of.
Yes, and they were brought as far as his affirmative...
Not as an independent cause of action.
Within the... No, but within the undue influence.
Umbrella of undue influence.
Yes. And so within that, Attorney Alexov has affirmative defenses on both of his answer and his amended answer, that he was acting as Ronald Kahn's agent, that he was acting as his fiduciary, that he was acting as his power of attorney.
So just by having a durable power of attorney doesn't make you a fiduciary. You agree with that?
Absolutely.
Okay. So where is there a finding that he's a fiduciary? It seems to me that this was I don't want to say a last-second kind of theory, but even I think according to you, you said when I was preparing my jury instructions, you know, you go down the rabbit hole, and I now see about this burden shifting with respect to the fiduciary. And it seems from then on, we start putting more force into that argument and then going down that path, which was 2 days before trial. So where is there a finding that he was a fiduciary?
By the jury on the verdict slip. So this was
on the first. That's on the first slip, right? There was no objection to the jury instructions. Is that fair?
Ultimately, they were agreed to.
No objection to the verdict slip. Ultimately, it was agreed to.
Yes.
Both the first one and the second one.
Yes.
Okay. So where was he found to be a fiduciary other than that first slip, which seemed to have, arguably, inconsistent findings?
But the naturalness of the disposition doesn't make it inconsistent, because once a fiduciary is found, whether or not the gift is natural or not, no longer is of relevance. Now, this is a matter where Attorney Alexov, throughout this process, denied that he was a fiduciary. So it was always in dispute until it came to the jury.
I thought I read in your papers that at some point it was undisputed that he was a fiduciary.
Well, we believe it is undisputed. I mean,
So which is it?
Well, it's undisputed in my view, but it was disputed by Attorney Alexov throughout.
But when it was undisputed per your view, did you seek any stipulation?
We did. And ultimately, the trial judge said, I'm not going to make that determination. I'm going to hand it to the jury.
So if there's no stipulation, then it's not agreed to.
Correct. But keep in mind, Attorney Alexov's a co-member of the LLC. He created the deeds. He drafted the deeds. He brought the deeds to the notary who knew he was an attorney and notarized it without his grandfather present. He held on to one of the deeds until post-death, and the other deed he held on to for months after it was allegedly signed. So he was taking all of these steps as an attorney, as a fiduciary, as somebody that was...
Grandson who was asked to do these things for his grandfather.
And Clary makes that clear, that's why the burden shift happens. And that is why, in this particular instance, the burden shifted. So we know before the burden shifts, when it's Mrs. Alexov's burden, we know that the jury found, on this first verdict slip, they found that there was no unnatural disposition.
I get it, but there was some confusion with respect, arguably, there was some confusion with respect to that verdict slip. And so when it seemed to be clarified by agreement, it seems, that's not what they found.
Well, it wasn't by agreement. It was very much objected to.
Without objection. At
When,
the end of the day, you were content with the verdict slip and the instruction.
well, I had objected so just to take us through what had happened here, the jury comes back and we get the first verdict slip, they read it. Judge Pappas dismissed the jury, discharged the jury. At that point in time, he says, okay, well, what are we going to do here? Well, pursuant to the complaint, declaratory judgment is what we're asking for. Strike the two deeds is what we're seeking. He says, well, I'm not going to do that. It's inconsistent. Well, how is it inconsistent? It's consistent for these X factors. I explained the burden shift, explained Clary, explained why this is in fact consistent. He says, I disagree. That time we step out of the courtroom, he goes to call them back. We learn that these jurors had all Googled the names. Well, when you Google the names, the probate court decision pops up immediately. And in that decision, we don't know what they read, how much of it they read, how long they were able to read it, but they were left to their phones for a considerable amount of time.
I thought it was 16 minutes.
That's a considerable amount of time to be reading whatever comes up on Google, especially given the fact that the entirety of the probate court decision is on there. We don't know what portions they read or not.
I understand, but the judge thoroughly spoke to each juror independently, determined that they were not biased or tainted in any way. So, go on.
But it was still clear error for that discharge to have occurred. And it was clear error to find that this was an inconsistent verdict slip. But we move on, and so the judge colloquies each and every, voir dire each and every juror. I believe Attorney Alexov requested a mistrial at that point. And we move forward, and at that time, the jury gets sent back out. They write back.
Hold on. At that point, was there any... Judge, I get it. Note my objection.
Yes. There was...
What record is that?
There was objection on the consistency, the inconsistent verdict slip argument. What was made prior to the issue with the jurors, it was made very clear on the record.
But then you were content with the verdict slip, I thought you said.
Oh, subject to that objection. I mean,
Was it? Was it noted to that? Was it subject to that objection or not?
I believe it was. I mean, I believe, I can't cite the transcript right this second, but I believe I repeatedly made clear that, renewing my objection, but, so we get through that point. The first note from the jurors come back, and the jurors say, we're content, we know what we were doing, we answered it correctly. Sent them right back out again. This time didn't make any changes, just said reread pages 8 and 9 of my jury instructions.
Damages piece, Was that there?
So the damages piece, the issue with the damages piece, and the reason why under the fiduciary duty section that the damages was not included, or was agreed to not be included, was because we were seeking declaratory judgment. We weren't seeking the value of the properties, we were seeking the properties. That this is about two pieces of real estate, and these two pieces of real estate were subject to unlawful deeds, and those deeds should be stricken. And that's what we're asking this court to do, is to find that the original verdict slip response was in fact consistent, and to send it back to the trial court with a instruction to strike those deeds pursuant to the fact that there was.
I guess that's what I don't understand. Under either jury's verdict, the answers to special questions under the original and then the amended, the jurors basically, in my view, said a pox on both your houses. You're both getting 0. These cases should be dismissed, is my layperson taking from the verdict slip. So I guess, I don't mean this to sound cavalier, but why does it matter if ultimately the jury said nobody's getting compensated here?
Because the jury really doesn't say that. They certainly don't say it in the first verdict slip, because there's no spot for damages. So we're relying on the fact that we're seeking declaratory judgment, and that's why they were never asked to give damages there. By the time we get to the second verdict slip, by the time that second verdict slip is returned, it's just shy of 4 o'clock. The jury had already been discharged at 10:30 for the first time, or 11 o'clock for the first time. And it's a question of whether or not they're coming back the next day. Every question was...
It happens all of the time. We can't base a case on what time the jury comes back. I guess, so you're not looking for a new trial. You're looking for us to remand it to Pappas to say, strike the deeds?
Ideally, yes. In the event that that is not agreeable, certainly the actions with the jurors and what followed, we would be seeking a new trial, because it would be grounds for a mistrial. But
you say the original verdict slip can be harmonized. Can you explain to me how?
Yes. So you take an the undue influence claim. The first question on there is whether or not there was an unnatural disposition. The jury says no, there was no unnatural disposition. It's very natural for grandpa to give to grandson a house. That's not the question. When we get to question 3, however, we ask about the fiduciary duty. And the fiduciary duty says, does KRIS Alexov have a fiduciary relationship with Ronald Carr? Yes. It's a whole new undue influence claim now.
Did the jurors ask a question about that?
They did not.
Didn't ask a question about, can a durable attorney be a fiduciary, or didn't I see a question about that from the jury?
That does remind me, yes, they did ask that question, and I do not recall what the answer was.
The judge pointed him to pages 8 and 9, perhaps, of his jury instructions, or some pages. 8 and 9 may be the wrong pages, but I think the judge pointed him to some pages.
He just continuously pointed. I think that was after the first verdict slip went in, so that was between the 2 verdict slips. But then, in question 2, it asks whether or not KRIS benefited from such a transfer. The answer was yes. And then, so the following questions are: did he meet his burden of proving that it was that the decision to transfer the properties was fair, and that Ronald was fully informed? No, he did not meet that burden. Did he meet his burden of showing the absence of undue influence? No. Did he meet his burden of proving the absence of fraud? No. That's why the burden shifts. Once it shifts, it doesn't shift back, as Clary says clearly on page 293. The burden does not shift back to the contestant.
Clearly, it was a slightly different postured case, right?
It's a very different, because now you have a fiduciary involved. Until there's
the 2 brother and nephews, is that the clear?
Oh, yes, that's the, but it's a very similar case at the same time, because you take the cases that come off of that case, which is, the I can never say it right, but the Remeldakis case basically asks whether or not, kind of carves that out a bit, and what that does is, it says, well, here the fiduciary brought about these deeds, just as in this case, that the deeds were brought about by Attorney Aleksov's actions. He drafted the deeds. He took them to the notary to be notarized. He recorded the deeds. He was a central figure in bringing about these transfers. The Smith case, which goes all the way back to 1915 and is quoted in Clary, that it places the burden on the grantee to prove fairness. And that applied to inter vivos transfers, and it's not tethered to pleading a fiduciary duty account. So that answers your question also, that there isn't a requirement to have a separate pleading. Sure, it would have been cleaner to do so, but there isn't a requirement to have a separate cause of action.
Time has expired. Let me check with the panel. I see no additional questions, so we're going to have to leave that right there.
Rest of my brief. Thank you.
Attorney Alexov.
Thank you, Judge. KRIS Alexov, on behalf of 28 Bradford Street LLC and myself, may it please the court. Cleary absolutely states that a cause of action for an independent cause of action for an equitable breach of fiduciary duty is required to have burden shifting occur. It's very clear. It's in footnote 4, I think on the 3rd or 4th page. Because in Cleary, what's important is even though one of the brothers was a fiduciary, the plaintiff brought a fraud claim against him and the burden didn't shift, right? And the SJC noted that. They said that was the judge properly handled that by placing the burden on the plaintiff. And so I think it's very clear, and this is, it's been 26, 7 years now, and the SJC hasn't come back and said, no, we really meant this happens in all undue influence cases and fraud cases. There hasn't been a case yet that says that. And so in this case, in our case, there never should have been instructions about fiduciary duty. There never should have been, there was a...
Did you object to those?
I did. Multiple times on multiple days because as Justice Desmond raised, it was 2 days before trial. We would have handled this case entirely differently. We have a fiduciary duty claim. You have experts. You have all sorts of different things to come into play. By this point, we have already we already have our defendants, or our witnesses ready to go. We have our defenses ready. I mean, we are ready for trial. We're not ready to handle a brand new claim. Now, the plaintiff amended their complaint once. If they so chose, they could have tried to do that earlier. And then that would have been fair to us to be able to try to respond to that. But they didn't. And it's because they're talking about a durable power of attorney that was used 6 years prior to only to lease a car and never used again. And it's kind of an absurd argument to say that just because there's a power of attorney out there, you are a fiduciary in all things forever. I mean, it doesn't even take the consent of the person who accepts the power of attorney to even be named one. I could name anyone in this room as a power of attorney. That wouldn't create a fiduciary relationship.
At one point, either in your answer or in somewhere in the pleadings, did you identify yourself as a fiduciary?
Pardon me?
Did you identify yourself as a fiduciary at some point in either your answer to the complaint or in somewhere in the discovery?
In an affirmative defense, there was an allusion to a power of attorney that was being used. But it didn't specify in which case, and as we all know, affirmative defenses can be pled in the alternative. You don't have to use them. Just if you don't raise them, they're waived. And at the time that the answer was made, we wasn't sure exactly what claims were coming in, what kind of control issues were going to come into play in this case. And honestly, it was just an affirmative defense. It wasn't an averment. It wasn't, contrary to the plaintiff's statement, it wasn't a verified answer. It was just an answer to a complaint.
Do you think the answers to the special questions in the original verdict were inconsistent?
I do, Judge. I do.
So if they were inconsistent, tell me how.
Because the jury made other findings, especially that there was a promissory estoppel claim where a promise was made and reliance on that promise was found, everything except damages on that claim. And they would have found damages, obviously, if there had been some loss, but there wasn't, right?
Did you object before the jury was discharged?
I did not get a chance because the judge raised it before anybody had a chance to object.
Well, I don't know about that. He discharged the jury, and then I think made a determination that the answers were inconsistent and then called the jury back. So that timeline is important.
My recollection is this, Judge. As soon as he dismissed the jury, he walked off the bench. There was not a time to sit to object. He was off the bench. And then he came back out. And
you say it's inconsistent in which questions and answers? 1 and 3?
Yes. The undue influence claim is inconsistent with the breach of fiduciary, I guess, questions, which weren't supposed to be a claim. I mean, everybody agreed that it wasn't a separate cause of action. The judge made very clear that he read the complaint and this wasn't a separate cause of action for which damages could be issued. It was And it was over my objection, my strenuous objection, multiple times that this information was included. And I mean, I think I went so far to say, as judge, if you give these instructions, I'm going to lose, right?
When did you request a mistrial?
It was after the jurors came back and were looking at had been allegedly looking at their phones.
So after
First.
the judge inquired of the jurors?
I believe it was after that, yes. And he never ruled on it. So.
Do you agree, in your brief, you talk about the fact that the plaintiff didn't separately plead a breach of fiduciary duty claim, but do you agree under the umbrella of undue influence, breach of fiduciary duties on the table, if you will?
No, I don't. It's a very separate, distinct claim. It's used when you allege a special relationship between two people that creates a relationship, and it has to be very specific, right? It can't just be you're a fiduciary in all things forever. And I think there's a professional rules responsibility rule that says that, and it kind of goes to this, attorneys can draft documents for family members where they receive a beneficial interest. Otherwise, it is their duty to prove that they acted fairly, right? And so there's a special carve-out in that niche for situations like this. And you would think that if a breach of fiduciary claim was required to be pled, that rule wouldn't be there, right?
I don't see any other additional questions. We can take the rest of your argument on your brief if you'd like.
Thank you, Judge.
Okay, both matters are now submitted and under advisement. I thank you both. That concludes today's session in this courtroom. I would like to thank the court staff, in particular our court officers, our wonderful timekeeper, our law clerks, and the clerk's office. We are now in recess. Thank you.
All rise.